Great. Welcome to the fourth public hearing for the inquiry into the acquisition of land in relation to major transport projects. Before I commence, I'd like to acknowledge the Gadigal people who are the traditional custodians of the land on which the New South Wales Parliament sits. I'd also like to pay respect to Elders past, present and emerging of the Eora Nation and extend that respect to other Aboriginals present or those who may be watching the live stream today. Today's hearing is being conducted virtually. This enables the work of the committee to continue during the COVID-19 pandemic without compromising the health and safety of members, witnesses and staff. I would ask for everyone's patience through any technical difficulties that we encounter today. If participants do lose their internet connection and are disconnected from the virtual hearing, they're asked to rejoin the hearing by using the same link as was provided to them by the committee secretariat. So today we'll be hearing from the New South Wales Valuer General and members of Save Our Homes Janali. Before we commence, I'd like to make some brief comments about the procedures for today's hearing. While parliamentary privilege does apply to witnesses giving evidence today, it does not apply to what witnesses say outside of their evidence at the virtual hearing. I therefore urge witnesses to be careful about comments you may make to the media or to others after you complete your evidence. Committee hearings are not intended to provide a forum for people to make adverse reflections about others under the protection of parliamentary privilege. In that regard, it is important that witnesses focus on the issues raised by the inquiry terms of reference and avoid naming individuals unnecessarily. All witnesses have a right to procedural fairness according to the Procedural Fairness Resolution that was adopted by the House in 2018. There may be some questions that a witness can only answer if they have more time or with certain documents to hand. In those circumstances, they're advised to take the question on notice and they will then be required to provide an answer within 21 days. Today's proceedings are being streamed live and a transcript will be placed on the committee's website once it becomes available. Finally, a few notes on virtual hearing etiquette to minimise disruptions and to assist our Hansard reporters. Could I please ask committee members to clearly identify who questions are directed to? Presumably when there's more than one witness in front of us. Could I ask everyone to please state their name when they begin speaking, again, particularly in circumstances where there is more than one witness. Could everyone please mute their microphones when they're not speaking? Please remember to turn your microphones back on when you're getting ready to speak. And if you start speaking while muted, please start your question or answer again so it can be recorded in the transcript. Members and witnesses should avoid speaking over each other so we can all be heard clearly. And to assist Hansard, may I remind members and witnesses to speak directly into the microphone and avoid making comments when your head is turned away. I now welcome our first witness. I remind Dr. Parker that you have appeared previously before the committee to give evidence, so you will be examined on your former oath or affirmation for today's hearing. Dr. Parker, would you like to start by making a short statement? If so, please keep it to no more than a couple of minutes.
Thank you, Chair. I made a brief opening statement at the last meeting of the committee, which I don't have anything to add to at this point, so there's probably no need for a further opening statement.
Too easy. Thank you. So we will commence with questions from Mr. Searle.
Thank you, Madam Chair. Adam Searle. Good morning, Mr. Parker. Good to meet you virtually. Mr. Parker, you've given evidence, I think, to this inquiry, but also to the Joint Standing Committee on the Office of the Valuer General about what I'll neutrally call difficulties within the Office of the Valuer General or the public service staff working with you to deliver the valuation services. And I think I'm right in saying that your evidence was that staff had triggered a process leading to a work health and safety investigation. One of the consequences of that was a directive, I think as you put it, from the former Secretary of the Department of Planning, Mr. Betts, that you only interacted with a limited number of staff, and you had described that arrangement as unworkable, rendering the operation of the Valuer General as dysfunctional, and that it constitutes an interference with your independence. Now, I note that the Minister at the time subsequently rejected those characterisations in budget estimates. We've now gone through 2 more department secretaries since Mr. Betts. Can you update the committee as to what is the status of that directive? Is it still in place? And how are those working arrangements unfolding in practice from your perspective?
The current secretary is on the verge of issuing, through the deputy secretary and myself, a joint statement to staff whereby the former secretary's letter of the 10th of May 2021 is rescinded, and I have unlimited access to communicate with staff.
Okay, and that's going to happen in the near future?
I understand so.
Okay. Now, I think it was also your evidence to the Joint Standing Committee that there was this work health and safety investigation because of concerns that staff had, that they felt anxious and fearful. I think there was an initial assessment report which you I think provided to a committee. What is the status of that investigation as you understand it? Has it been completed? Have you been asked to respond to the draft?
It has been completed and I have responded to the draft.
Okay, so you have seen the draft, you've responded, and there is a final report somewhere?
There will be, I would assume, a conclusion of the process by the department.
Do you have any idea about the time frame?
It links closely to the joint statement by the Deputy Secretary and I on communication. So to that extent, its completion is imminent.
Okay, imminent, okay. All right. Now, in budget estimates evidence, the former Department Secretary, Ms. Fishburn, indicated, and I quote, she can confirm that there are a number of investigations underway in relation to matters concerning staff and the valuer general. Apart from that work health and safety investigation, are you aware of a number of other investigations into your conduct vis-a-vis the staff working to you?
I am not, with the exception of the investigation into a complaint that I made about a staff member, which is also...
Okay, but that's a complaint you made, but you're not aware of any investigations into your behaviour, apart from that one work health and safety one. Is that correct?
Correct.
Okay. All right. And so what has been the impact from your perspective of the directive while it has remained in place? What have been the practical consequences?
It created a level of confusion in communication with staff, as all communication went through an executive director, and therefore there's the risk that communication isn't always as clear as it might be, or perhaps that what I said didn't quite make it in translation.
Right. Okay. So, and do you feel that impacted the effectiveness of the office and yourself in terms of making valuations and completing valuations in a timely way?
In the context of the just term space that this inquiry is focused on, yes, I think it probably did.
Okay. All right. Now, all of these matters appear to have occurred in the context where the People Matters Employment Survey from, I think it was about February 2020 onwards, found that there was a lot of negative staff sentiment in relation to the Valuer General, and that there was also an additional survey of staff sentiment called Team Gauge, which led to such a degree of negative reporting about staff sentiment in relation to what I'll call the Valuer General, that in fact that level of staff sentiment testing was discontinued. What can you tell us about that?
No more than you've just told me.
What, so you're not aware of the Team Gauge staff sentiment gauging being discontinued because the level of negativity essentially directed about your behaviours was at such a level that they just stopped taking that temperature?
I was aware that it had been suspended. My understanding was that the suspension also had regard to the impact on my mental health of constant, be it either valid or invalid, criticism raised by staff. Team Gauge, being an anonymous document, provides staff with an opportunity to say anything unfettered without any need for substantiation about anybody in the organisation.
Okay, but just to be clear, you're aware of difficulties that you have experienced with staff working to you and difficulties they've had with you. You're aware of that, at least at a general level?
Yes. Now, I appreciate the committee's guidance as to the relevance of this to the just terms process.
It's really about the impact that all of this context would have on the operation and the effectiveness of the Office of the Valuer General, if I can use it that term. Probably not the right technical, but I'm really talking about, you know, your discharge of your statutory duties and the discharge by public service staff of their duties in assisting you fulfilling your duties.
I believe you asked that question earlier and I answered it. And the department is a service provider to me, so it is a matter for the department to provide the services.
Yes, okay. All right. But you're aware that the Team Gauge sentiment detected, you know, high levels of what was described, at least by staff, as intimidation and bullying. You're aware of that, at least at a general level?
I wasn't aware the terms intimidation and bullying had been attached to the Team Gauge.
Okay, all right.
I would stress, however, they are anonymous,
of course,
completely unsubstantiated, and staff may write whatever they choose to write in the Team Gauge survey.
Okay, but what do you ascribe? I mean, in terms of the People Matters and the staff survey, through the People Matter survey, the Team Gauge survey, you've had the work health and safety investigation. I mean, all of this suggests an unhappy workplace for some reason. What do you ascribe that level of unhappiness to? Do you have a view about that?
I have a variety of functions to discharge under the Act. In order for me to discharge those functions, I choose currently to seek services from the department. Those services need to be provided in full, and when they aren't, then issues with staff may arise. Management of issues with staff is a matter for the department.
Right, but what about once the Secretary's directive is rescinded? Do you go back to managing the staff more directly yourself?
No, the Secretary's directive dealt with communication, not management.
Mm-hmm.
The management of the staff is a matter for the department. I will have an unlimited right to communicate with the staff.
Okay, I understand. Now, are you aware that the Legislative Council has done a call for papers on the department about these matters, about complaints made about the Valuer General?
I am.
And in fact, I think in response to that call for papers, you and your office made a nil return. You didn't possess any of the documents.
That's correct.
Okay. But would you be surprised to learn that, at least at a level of generality, a number of the documents returned suggest significant staff disquiet about you and your management of them and of the way in which you interact with people in the workplace?
Point of order, Madam Chair. This is an inquiry into land acquisitions. The general management of the Office of the Valuer General is one thing when it's connected to land acquisitions, but when it's broadly connected to just the management of the office, I don't think it falls within the terms of reference of this inquiry.
To the point of order, Madam Chair, the committees of the Legislative Council have always taken a flexible approach to these things. I think anything which might impact negatively on staff performance, however you want to describe that or view that, does impact all of the discharge of the statutory functions of the Valuer General, and that would extend to the matters that are the subject matter of this inquiry.
Thank you. I will caution members to bring this back to the terms of reference, and in particular, I think in this line of questioning, to bring it back to the delays to potentially to the offers of compensation that have been made. But I will leave that in your hands, Mr. Searle, but if you could connect it back more clearly, that would be appreciated.
Okay, well, I've nearly concluded this line of questioning anyway, but I just wanted to, just to make sure I've understood Mr. Parker's evidence. Clearly, Mr. Parker, you're aware of only one substantial complaint about yourself, that is the work health and safety investigation, correct?
I'm aware of one investigation. The department has been at pains to say that that was not a complaint related matter. It was a workplace health and safety related matter.
Okay. How do we reconcile that with Ms. Fishburn's subsequent evidence to budget estimates that there were a number of investigations relating to complaints?
I'm unable to answer that question.
Okay, that's fair enough. And as far as you're aware, all of these matters are now either concluded or about to be concluded. Is that correct?
As far as I'm aware.
And do you have an idea, and I'm not asking you to tell us because we'll wait and learn at the appropriate time, do you have knowledge about how those matters will be resolved or what the outcome of those investigations will be?
The conclusion of the workplace health and safety investigation is a matter for the department.
Yeah, but my question was, are you aware of what the department is likely to say in that final report?
I've had some discussions with the department, but the final decision is a matter for the department.
All right, well, I think that's probably all I'm going to get from Mr. Parker. What has all of this done, all of this turmoil, if I can put it that way, what impact has that had on delaying the discharge of your functions and the timely completion of the valuations? Has it slowed it down by 10%, 15%, not at all?
It's not a statistic we measure.
No,
we measure the number of determinations issued within, or the average time taken to issue a determination. I am aware that the number of reports outputs that are issued has gone up very significantly. So the volume of outputs is greater. The quality is relatively unchanged, but the volume of outputs has increased significantly since the department restructured its management team.
Could I just jump in with a question there? I know that the residents at Riverwood have been particularly concerned about the processes applied to their home acquisitions. And it was reported quite recently that they finally received an offer for compensation. They were told on February 16, 2021, that they would be subject to this compulsory acquisition process, but have only just, almost a year later, received that offer. Was that as a result of these issues within your office, or do you see that as being a sort of a fair time for that offer to be made?
Well, my role in compulsory acquisition only arises at the date of gazettal. Prior to the date of gazettal, there is a 6-month period and a 3-month period whereby the acquiring authority may negotiate with the claimant. So, from memory, the 3 Riverwood matters were all concluded and preliminary reports issued within the 45 days required under the Act from the date of gazettal. Now, I'm unable to comment on what may have happened before the date of gazettal, that is between the claimant and the acquiring authority, but from the date of gazettal, we issued the 3 preliminary reports from memory within the 45 days required under the Act. So the Valuer General's involvement was extremely, in this instance, timely. So
could you explain to me then, so just, sorry, for the dummies, explain to me why they've only just got the offer of compensation now? Are you saying that's because the process prior was not done in time?
Well, the process starts with a 6-month negotiation period.
Mm-hmm. That takes us to August. Yep.
During which the acquiring authority and the claimant may negotiate a settlement. The acquiring authority will then issue a proposed acquisition notice, a PAN notice. There is then a further 3-month period for the parties to seek to reach agreement. My understanding is that generally, during that period, the acquiring authority will make an offer or offers to the party, and negotiation may occur. If the parties are unable to agree by the end of the 9-month period, then the acquiring authority will ask the governor to gazette or to compulsorily acquire the land by notice in the Government Gazette, and that is the date at which it comes to my office for me to make a determination. Now, I don't make an offer, I make a determination, and under the Act, within 45 days, I'm required to provide that determination to the acquiring authority, who then provide it to the claimant in what the Act refers to as an offer, but effectively it's non-negotiable. That is the final number, subject to any subsequent court proceedings.
Understood. So this delay then is really the acquiring authority's responsibility, or yes, is it a product of the provisions of the Just Terms Act?
It's a combination of the two. So you have the framework within the Act, and then you have the process between the parties. So the critical time period for me that the department has been focusing on my behalf is the 45-day period under the Act, in which Valuer General is required to make a determination.
And can you confirm, when it comes to the amount that was offered to the Janali residents, that amount is based on market value 2 years prior to the date on which you give your determination? That's correct, isn't it, under the Just Terms Act?
No, I'm not quite sure that's the case.
Okay.
My determination is the market value at the date of gazettal. Now, in a period of 9 months before that, the acquiring authority may make a series of offers. Those offers may vary if the property market has varied during the period. But if the Act is being followed, the whole process should be constrained to a period of 9 months. Now, we have had, as our recent revaluation showed, significant increases in value over the 2021 year. So within a 9-month period, it is possible that an initial offer by the acquiring authority may be lower as values move. They may choose to make another offer, they may not. But my valuation is as at the date of gazettal.
Okay. So, and there's nothing under the Just Terms Act that currently provides for this situation where, as we've seen over the last year, house prices have absolutely ballooned, and people who are being bought out are now trying to find similar housing and finding that obviously this housing is much more expensive than what they're being offered for their homes. That's a product of the Just Terms Act, correct?
I think there are two issues perhaps there, Chairman. The first is that it is entirely open to the claimant during the 9-month period to negotiate with the acquiring authority, and if values have risen in the area, then they can ask for a greater amount of compensation. Now, as I mentioned last time I addressed the inquiry, a fundamental flaw in the legislation is that you are compensated for that which is taken away from you. You are not compensated for that which you will then have to buy. So the Act doesn't say 3-bedroomed house in Riverwood and the compensation will be another 3-bedroomed house in Riverwood. The Act says the compensation will be the market value. It may be in many markets that you can't find another house that suits you for the money you got in compensation, but that is the structure of the Act.
Thank you. That's very useful. And if, I guess when you talk about it's within the resident's power to accept an offer during that negotiation period, that is a bit reliant on the acquiring authority being open to offers that perhaps more accurately reflect just compensation. But if they know that your valuation will be as at the date of gazettal, then perhaps, does it, in your view, then throw out the incentive to make a fair offer based on increasing house prices?
No, because the acquiring authority knows very clearly that if they can't agree, it will come to me and it will be the market value. So they know exactly where the goalposts are. And it's really, in terms of equity and fairness, no benefit to an acquiring authority to play games. They're going to have to pay market value. So
yes, but your previous comment was if people don't want that market value as at the date of gazettal, then they do have that opportunity to negotiate. If that is setting the goalposts, if that valuation or the eventual kind of possible valuation that then gets it forms the basis of the final offer is there, then what incentive is there for the acquiring authority to offer something better than what they might get through the valuation?
Well, that would be a matter for the acquiring authority. They only have to offer market value.
Yeah, seems like another thing we need to fix under the legislation. Mr. Banasiak,
I might just extend that prior point, because
yes,
there is a significant issue on the claimant side, that the claimants, in my experience, tend to approach the negotiation period with a view on the worth of their property rather than the value of their property. So the worth to them is invariably higher than the market value. Obviously, if they've lived there for many years, they've brought their children up there, it's been the family home, it's been the centre of family life. In their minds, its worth is greater than its value. And the Act is very clear that we are dealing with value. We're not dealing with worth. And so, on my observation, the negotiation period is often marred by claimants being unable to contemplate market value when they have an assessment of worth in their mind.
And as you said before, when they are looking at a replacement, a like-for-like replacement cost, which is, far exceeding the amount that they're being offered.
Yes, sadly, they're not compensated for a like-for-like replacement, with certain exceptions, such as equestrian centres, churches and things like that. But generally, it's not a like-for-like replacement.
Mr. Banasiak.
Thank you, Chair. Mr. Parker, in our last year, and we asked some supplementary questions of you about comments you made about non-compliance with value general policy, court precedent or Act, and you came back with some examples, more specific examples of where you had that non-compliance, and I thank you for that. But I was just interested in where you say the most common examples of this non-compliance. If those, I guess, determinations or non-compliant determinations were allowed to stand, would that have resulted in a net loss or a net benefit in most cases for the landholder, if that was allowed to have slipped through to the keeper?
If they had, to use your phrase, gone through to the keeper, the state would have spent somewhere in excess of $100 million more than it has since I started reviewing reports.
So am I right in saying that non-compliance was actually giving landholders potentially more money than they should have been given?
That has been the experience so far, to in excess of $100 million.
Okay, thank you. That's probably not what I was expecting, but it's still disturbing nonetheless. I might pass back to the chair if anyone else has some other questions.
Yeah, Mr. Graham.
Thank you, Chair, and thank you, Valuer General, for appearing. I just wanted to follow up on some of those issues you're drawing attention to in the way the Act operates. The committee at the moment, having heard from quite a few residents by way of formal submissions or at these committee hearings, is now moving to really say, we know there's been some issues identified, what changes might be required. You've identified some there. I might just ask you to be more specific. When you talk about that conflict between being compensated for that which is taken away, not what you need to buy. Do you have a suggestion about how the Act could be changed, or how the compensation process could be changed in order to tackle that? If you've got a specific suggestion in mind, or are you really just drawing attention to that tension?
No, I'm just drawing attention to the tension. It's a tension that hasn't, as I understand it, been resolved in other Commonwealth jurisdictions who have the closest regime to ourselves. And there's a fundamental public policy issue there as to what the possessed party should get, reflecting the benefit to them and the benefit to the community as a whole.
Yeah, and I think you also draw. I think you also draw attention to another fundamental tension, that idea that you were just expressing about, for these individuals, the worth might be separate from the worth of their home, might well be separate from the market value. How often do you see that in the evidence to the committee? We're obviously seeing that come through strongly, but that may just be that, of course, we're having people come forward who feel that way. But is this, that sounds like a relatively systematic problem that, of course, someone's home really means a lot to them. It is their neighbourhood where they live. They've grown up, their kids have grown up there. Is it systematic, or is this the case some of the time in your experience?
Well, I would suspect it would be systematic in the sense that it potentially occurs across the system. In terms of the frequency, the acquiring authorities may be better placed to answer that, because I only see matters when they've reached the point of an inability to agree. Now, by the time they get to me, the assessments of worth generally have become very, very entrenched. They tend to arise very often with different views on interpretations of planning instruments, interpretations of the law, and one of the products of 9 months of negotiation is each party digs themselves in very deeply. Yeah,
and that makes sense. Having survived the process and its rigours up to then, people are very, and dealing with an issue which is quite emotional for them, people have really dug into that sense of the worth of their home. In relation to changes to the system, is that distinction recognised in other jurisdictions in the way that other laws are written?
No, as far as I'm aware, the market value concept is prevalent across Commonwealth jurisdictions.
These are important powers for the state. It's an important ability for the state to do something in the public interest, to really acquire land where it serves a public purpose, and some of the time that obviously will impact on individuals. But if they don't work smoothly, if people do feel systematically that the worth of of their home or what the state's taking from them is being undervalued, that undermines the whole system and these important powers. Is that where we're at now, given the level of acquisitions that are going on? Do you see a need for change here in the Act, or how those two distinct ideas are used in the system? Or is this just inevitable, an inevitable tension in the use of these powers?
I think it will be an inevitable feature of the use of the powers. What I do note is that I understand the vast majority of acquisitions are settled by the acquiring authorities by agreement. A minority are then gazetted, and we have a process whereby each party is able to make submissions and share their views on the value or worth of their property. I make the determination, and the number of determinations that are appealed are exceptionally low. So the system, whilst there is a lot of noise, would appear from a overall community fairness level to work well. Obviously, any system has scope for improvement.
Yeah.
Implementation of any processes have scope for improvement, but we essentially would appear to have a system that is overall fair to the claimant and fair to the acquiring authority.
I might just finally ask about a specific proposal, and I don't want you to talk about the circumstances around that individual instance, but about one of the observations of the group we're about to have to the committee, and that's the group in relation to the Janali commuter car park project. I just want to put one piece of evidence they put to you, and I'm interested in what you think this means for the system. So I don't feel obligated to comment on the specifics of Janali. What they say is, and I'm quoting now, the proposed Janali commuter car park project was not carried out in a proper manner and did not meet the regulatory requirements, and therefore it was ultimately unjustifiable. That's not what stopped it. It would have gone ahead. The current regulatory framework is deficient. What stopped it was the effective public protest they were able to mount. That's the view they're about to put to the committee. Do you have any reflections on that? And do you, in your view, is the current regulatory framework deficient? Are there concrete improvements we could make as a part of this process?
Well, no, I don't have a view on those comments. As I mentioned earlier, the current framework would appear overall to be effective in being fair to most claimants and the community in general.
Thank you.
I'll just interrupt you there, Mr. Graham. I see that Mr. Vanasiak wants to ask a question, and I will then also ask if the government have any questions before we finish up and come back to you, Mr. Graham, if we've got time. Mr. Vanasiak.
Thank you, Chair, and thank you, Mr. Graham, for the indulgence. Just going back to my previous questioning, have you taken any steps to ascertain how many potential agreements were made, or mutual agreements were made in recent years that would have potentially been non-compliant if they've actually come to you for adjudication? I just want to try and understand the scope of potentially this poor decision-making that's being made by valuers within DPI.
No, I have not reviewed the decisions of prior valuer generals.
Do you plan to, given considering the amount or the concerns that you raised about non-compliance, are you considering going back and reviewing some of those mutual agreements that were made, just to get a sense of the scope of the problem?
I have no, as far as I'm aware, I have no statutory power to revisit previous determinations. I have, however, taken very significant steps to address the issues going forward as soon as I became aware of them.
Okay. And do you think it's a training and education problem, or is it a cultural problem? Where is the breakdown happening in non-compliance with policy and legislation?
Well, that is a matter for the department. I buy services from the department. It is a matter for the department to provide those services, and so where the essence of the problem may lie is a matter for the department.
Okay, thank you. Back to you, Chair.
Thank you. Mr. Graham, did you have further questions, or Mr. Searle?
I would like to just continue putting a little bit of that line of questioning, but I'm happy for you, Chair, to intervene if you've got something first.
No, you go ahead. I understand the government don't have questions, so we have another 6 minutes or so.
Right. So, Valuer General, I might just put an alternate view to you about the state of the system and ask for your comment. On the view that's been put to us by many of the submissions is that because of the contradictions you've drawn attention to, I think that's fair to say. I think you've really characterised the tension in the system well. Because of those tensions, the public feels, certain elements of the public, the affected members of the public, a small number but deeply affected, feel the system is not working, and that is impacting on the credibility of this important power. And this necessary power for the state. But secondly, we have had relatively strong evidence that through the committee and frankly outside of the committee process, that the culture of acquisition with the Metro agency is causing significant community concern. That's a cultural problem, not a legislative one. Those are at a level which is of real concern. That's the view that's been put to us. But I might just ask you to comment on those things if you choose to add anything, given your the evidence you've just given that really there are tensions, but the system's working well.
Well, I'm unable to comment on individual acquiring authorities because I have no knowledge. And I mean, one of the fundamental issues is, by nature, it is a compulsory acquisition. Therefore, it is not something any of the claimants necessarily want. It's something that is forced on them for the overall community good. And so human nature would be to resist and be unhappy with anything that is compulsory, in which fundamentally you have no right to say no.
Yes, but it's not compulsory that people are upset by the process or aggrieved by the process or put through an incredibly tumultuous time by the process. None of those things should be compulsory. Why don't we recognise the principle you're saying, that almost across the board people will feel that their home is worth more than the simple market value for all the reasons that you've articulated, and I think anyone in the public would understand? Why can't we tilt the system to recognise exactly the principle you're outlining?
Well, that is entirely a matter for government. Government may choose to. One scenario that is often posited is that there should be some kind of premium paid, so market value plus 10%, market value plus 15%. It's entirely a matter for government whether it wishes to do that, and we have absolutely no problems with whatever government wishes to do. We will implement it.
And are you aware of discussions in government about consideration of moving towards some sort of system such as that, market value plus 10%, given the scale of the acquisitions that are going on at the moment?
No, I was unaware of that.
Are there other jurisdictions which do recognise that with a market premium?
Not that immediately spring to mind. It was a feature of the very early private acts in the UK in the mid-1700s for the building of the canals and the railways, where it was market value plus a percentage. But then as the various Commonwealth jurisdictions matured, the plus a percentage faded away and it became market value with compensation for other things like what used to be known as solatium, the loss of your principal place of residence, severance, injurious affection, and other things. So,
fast forwarding from the 1700s, do you have a view about what an appropriate market premium might be? You know, how much of a distinction do you see here between these two ideas? I know that's a difficult question.
I don't have a view because it is a matter for government how much it wishes to benefit the dispossessed.
I accept that. Look, I think that's fair, and I don't want to put you in a position where you have to give evidence you're uncomfortable about. Let me put it to you this way, though. In the view of, with your knowledge of the system, how much of a gap is there when people assess the worth of their own home compared to what is being paid out in the market value in the cases you have experience of? Perhaps that's a better way to...
Yes, I haven't analysed that.
Okay, thank you.
Okay, Mr. Searle, did you have any final questions? We've got half a minute left. No? Okay, well, that's very tidy of us to finish our
I don't have any questions.
All right, thank you very much. And thank you very much, Dr. Parker, for attending again to respond to our queries. I don't believe anything was taken on notice, but to the extent it was, you'd have 21 days to respond. Thank you, and that is all for you today. And we will now commence our next session with the Janali residents. Thank you.
Thank you. Goodbye.
Excellent. Thank you. I can see you now. I couldn't see your videos before. I was worried that you weren't there. Thank you very much. Lovely to see you, and thank you for your time today. Before we kick off, I do need to swear you in. So if I could get you to state your name and, if relevant, a position title or what you're representing, I guess, and then swear either the oath or the affirmation. And if I could perhaps start with you, Mrs. Mulhall.
My name is Wilhelmina Mulhall. I'm the owner of 7 Mary Street, Janelli. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you. And Mr. Mulhall?
My name is William Mulhall. I'm also the owner of 7 Mary Street. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you very much. And Mr. Richards?
Hi, I'm Tom Richards. I'm a resident of Janelli and part of the Save Our Homes resident group. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you very much. Would you like to make a short opening statement? I'll start. I don't know if you want to both make a statement. Maybe we'll start with you, Mr. Richards.
Yeah, no problem. Thank you. Thank you for the opportunity to be here and talk to you all today. Believe it or not, we're the lucky ones. The group of families that have managed to reverse the decision of Transport for New South Wales to compulsory acquire 9 family homes here in Janelli in 2021, all for the sake of a commuter car park. We say lucky as we're fully aware of communities like Orchard Hills and Riverwood who have not been afforded the reprieve that we have. We've supplied a robust overview of our case and recommendations for the committee back in July 2021, but wanted to just lead out with a few key areas we think are in need of urgent focus. To reiterate to you all today, we are not a group that's anti-infrastructure and development, and we fully recognise the complexity of the job. But we do, however, feel that in our case for Transport New South Wales, the state government and our local member could have done a far better job. I won't touch on timings, that's in the pack that we've provided, but for full clarity, the date in which doors were knocked in Janelli was the 11th of February 2021, and Transport for New South Wales withdrew the compulsory acquisition orders on Thursday, the 4th of March. So it was around 3 weeks we were kind of going through this process. Our experience in the acquisition process here in Janelli was one that was severely lacking in planning and consultation. The interaction between key planning legislation and the compulsory acquisition powers afforded to Transport for New South Wales to ensure proper and full assessment of impacts from a proposal involving acquisition must be complete prior to commencing the acquisition process. Our experience was that the acquisition process was the start of this process, with all required planning approvals to be commenced at the conclusion of acquisitions. We would encourage the committee to review the due diligence processes that should be put in place to ensure that prior to acquisition taking place, Transport for New South Wales ensures that there's clarity on what would constitute a major infrastructure project and whether car parks should fall within this category. A justified and valid public purpose has been established, that there's been an opportunity for transparent and meaningful community engagement on options, and that there's credible evidence of the benefits to the public outweigh the hardship to those affected. It's our firm opinion that our homes were used as a wedge by Transport for New South Wales to expedite negotiations with the Sutherland Shire Council for the pre-existing car park in the Janelli shopping precinct. Once acquisition orders were given, within weeks, Transport for New South Wales had given the council a 7-day ultimatum to hand over an existing car park or risk losing the homes. The media were briefed in advance of the community of the commuter car park with accompanying quotes and artist impressions provided. And there was a lack of engagement and response from our local MP, despite phone calls, emails, letters, and requests for meetings. We were concerned during the process there was a conflict in position, as her role of the Parliamentary Secretary for Transport and Roads meant that she couldn't engage with us thoroughly. Our final point is that it's clear the impact of the commencement of the process has on those directly involved is considerable. From the moment doors are knocked, it's our firm opinion that Transport for New South Wales have no process for emotional or mental support to protect citizens' welfare. Instead, they're afforded a case manager under the employment of Transport for New South Wales and the option to privately fund legal support. The minimum standard of support, including mental health support, required to be provided by agencies when commencing these decisions is missing. A genuine intermediary process is required rather than a Transport for New South Wales employee marshalling affected families through the desired process at a pace in which they dictate. Transport for New South Wales case management standards and duty of care for affected homeowners once a process is enacted is sorely missing. Transport for New South Wales requirement to specifically plan for affected homeowners' circumstance and ongoing support requirements, e.g. constituents living with disability or a need for wider support prior to the enactment of the compulsory acquisition process, we feel would be beneficial to the community. So finally, although we have a sense of relief that the compulsory acquisition orders were withdrawn on our homes, the impact this left on our community is profound. There's been significant loss of anonymity for some, for others, a clear deterioration of trust in state government, and for the majority feeling that we're both underestimated and unnecessarily used as part of a wider deterioration of the relationship between Transport for New South Wales, the member for Miranda, and the Southern Shire Council. In a process that can often feel bereft of compassion, there needs to be a renewed standard to help impacted communities feel respected, informed, and cared for. I believe Liam and Helen have a short thing to say as well.
Thank you. Mr. and Mrs. Mohali. Sorry, Mulhall.
Yeah, hi. As previously said, my wife and I are owners and residents of 7 Mary Street, Ginnelly. Still, I'm very pleased to add, just over a year ago, persons from Transport knocked on our door and announced that our home would be compulsorily acquired to make way for a commuter car park. That began a traumatic and life-changing episode with permanent repercussions. We were therefore delighted when this inquiry was announced and gave us the opportunity to provide a direct victim's perspective in our submission. I'd just quickly like to emphasize a few points regarding that submission. Firstly, as the euphemistically named opening letter says, the decision to evict us had been made and the process actually started. That is in effect an eviction notice, masquerading as a negotiation. Also, there is no prescribed or practical process to challenge or appeal the decision. A lot of emphasis in inquiries is about the process of calculating proper compensation. I'd like to focus more on the process as to how the decision is made and justified, and how landholders' rights in this regard are protected. We understand infrastructure development is essential and forced evictions are sometimes necessary. Nevertheless, they are a violation of the fundamental human right to adequate housing, and as such require particular consideration and full justification prior to the decision being made, as laid out in the United Nations report, Basic Principles and Guidelines on Development-Based Evictions and Displacement. Those who decided that this car park in this place at this time was the right thing to do have never felt the need to explain or justify why. They didn't even have the common decency to acknowledge the greater harm being inflicted on us, let alone explain what greater good clearly outweighed that harm. They didn't treat us with dignity or respect. They treated us with contemptuous disregard. We were powerless victims of unscrupulous, powerful people. Fortunately, our neighbourhood had the resources to mount an effective protest campaign in mainstream and social media. The public immediately saw this for what it was, an unprincipled betrayal of Australian values, a moral outrage, and they were certainly outraged. Potential political damage from the resultant scrutiny and the unstinting unanimous support of the Shire Council is what stopped this project. To date, there's been no admission of wrongdoing, no consequences for such reprehensible behaviour, no personal price to pay, and therefore no incentive not to do so again. What is to stop such or similar unacceptable behaviours against others less able to effectively protest? As a layperson, I don't understand why we don't legally mandate that all compulsory acquisitions in this state must follow international best practice as defined by the UN. Thank you.
Thank you very much. I had the pleasure of meeting with you last April and with a couple of other residents who had been impacted And what really struck me was this sort of emotional impact. And I know that, you know, as Mr. Richards said, you are lucky, you are the lucky ones. This was a 3-week process for you, but your experience really gives us an insight into what you know, hundreds of people are going through across the state. Could you give us a little bit more of a, I guess, an understanding of exactly what happened when you were first told that your homes were going to be acquired?
Yes. Would it be okay if my wife responds?
Can I just do my little introduction too?
Of course. I'm so sorry. I didn't realise.
No,
Please go ahead.
no, that's fine. And then I'll continue on with that question. So thank you for raising this inquiry. Really appreciate it. Members of the Save Our Homes Committee have forwarded you an outline of the emotionally and financially traumatic experience we were put through by 2 elected government officials and Transport for New South Wales to announce the compulsory acquisition of our homes. I am horrified that 2 elected government officials felt they could bully, harass and intimidate families, the community and local council to try and achieve an outcome that would result in their party's election promise being met, in the hope that these 2 individuals would be re-elected. There was no concern for the emotional, mental and financial stress for us, the community and the government. The amount of taxpayer money these 2 incompassionate individuals wasted must be exorbitant, not to mention the financial cost to us and our neighbours to fight this event and pay for our medical expenses. I hope this inquiry can come up with a solution so changes are made according to the guidelines in place that results in the genuine good for the community and individuals' emotional needs are considered and fair monetary compensation is made. I understand things need to progress and change, but no Australian citizen should be subjected to this unethical behaviour as displayed by these 2 individuals and Transport for New South Wales. Yeah. So we were away on holidays and at 9:30 our house sitter rang us up and told us that a man had knocked from Transport New South Wales, had knocked on the door with his scribe and asked who lives here. They then proceeded to tell our house sitter of what was happening, who then had to ring us and tell us. Now, I'm flabbergasted that an organisation such as Transport New South Wales would do such things in that way. That is just horrific. The neighbour next door, she's a single mum with 2 boys. She was putting her sister's children in the car, all under 7. She got a tap on the shoulder. She had no emotional support with her. They said they were for Transport New South Wales. They asked if they wanted to come back later. Well, of course, something official like that, no. So she walked into the house with 4 young children under 7, where they proceeded to tell her she was going to be evicted from her house. She had nobody with her. The 2 people who lived behind us, an elderly sick brother and sister, well, the elderly sister was undergoing chemotherapy, knocked on their door. No emotional support. These people could hardly look after themselves. It was unbelievably cruel.
They say that, you know, in terms of stressful life events, you know, death of a loved one, divorce, and moving home are the 3 most stressful events that you will experience. Did the people who knocked on the doors seem to have any understanding of how stressful the message they were delivering was?
Can I just, oh, sorry, I'm taking over all of this. I know Mrs. Singh, she was absolutely horrified because the man was smirking at her while he was saying it. She was horrified. She was in tears.
Yeah, I think the common experience to answer the broader question, I think the experience that we have on the ground is when the doors are knocked, it's a very isolating experience for the homeowners that are most affected. So the 9 homes, there's no period of consultation. Like we're in an R2 zone residential area, never a conversation about a car park being here, never an assumption when you buy property here that would be coming. And these things change, we kind of understand that. But when doors are knocked, the individual homeowners are left on their doorstep on their own to contemplate what they do next. So I think that's the cruelest part of it, that there's not any kind of linkage outside of what we did as a community to bring people back together. My home is directly opposite the houses affected, so my driveway leads on to where the proposed car park would be. I never had a knock, a phone call, a conversation. I was informed about it via the press. That was the only way I found it. Someone sent me a WhatsApp message going, "Is this a picture of your house?" And there was an artist's impression of a 5-story car park directly over the road. So the feeling was that this was happening over the road from me. I had no idea that conversation had taken place. There was no formal conversation. The next point of communication was a pamphlet stuffed in our letterbox the following Monday. That was a Thursday. The following Monday, we had a sales brochure put in telling us about the electric charging points and solar panels the car park's going to have, and an innovative facade, so don't worry about it. But we really found from that first kind of interaction with transport that going out on your driveway, people were completely devastated. And it's a knock, it's a quick 15-minute conversation, here's a letter, see you later. And then they're left to pick themselves up. And I think we were lucky in our community that we had some very we're a very tight-knit community, so we could kind of step in and help support people, and we got together quite quickly. And to credit, the mayor in Sutherland Shire came and saw us on that Sunday and spoke to us. But it's devastating news to get, and it's even more devastating when you're kind of given a letter and then they just disappear. The next conversation starts being about valuation. I think that needs to be looked at.
So there's this devastating news delivered in circumstances where people are not expecting it at all. So it's this real shock out of the blue. Should these people really be turning up with some sort of, I guess, counsellor or psychological support?
We asked so many times. It shouldn't have even happened. They should have followed proper procedures, to get to that stage to knock on the doors. It was.
Yeah, if I may just interject. It's absolutely outrageous that the first thing we hear is a done deal, a fait accompli. We're taking your house. You're going to be evicted. That's the very first thing we heard about this. Nothing prior to that. They had been working on the project for 6 months, and they talk about consultation. It wasn't consultation. It was deliberately done in total secrecy. We were not, and this dawn raid, surprise, shock and awe attack was a calculated tactic to put us off balance and accept what they wanted us to comply with this process. That's my view.
Yeah, and I'll give just a really quick example. One of the homes affected have a son with cerebral palsy who had gone through a government grant process to add a ramp and electric door for their son so he can access the property. That was all government funded, and that would have been on record somewhere. When they knocked on the door to tell them that they were compulsory acquiring the home, there had been no consideration around, we will help you maintain this grant and move to another place. They had to go through that process and then go back to them within a couple of weeks to say, hang on, if we need to find somewhere else, we have needs within the family that need to be met. So we have to find a very specific property, or we have to go through the government grants process. And only then did transport kind of switch on and go, oh yeah, actually we should, we'll look into that and we'll let you know if that's something we can replicate somewhere else. And these are all considered, that's not hard information to find. I think there's a due diligence here that if you are knocking on someone's door and you're going to pull down their lives in 15 minutes in the morning, I don't think it's much to ask to spend an hour or two the day before to go, whose door are we knocking on? What might their needs be? And how can we best serve those needs in the coming weeks to kind of guide them through this process outside of appointing a case manager who's trying to conclude the process efficiently?
Thank you. Mr. Graham, did you want to ask some questions?
Thank you, Chair. I might just pick up on exactly that point just while you're making it, Mr. Richards, just to say, yeah, these are predictable problems. You might not know exactly what the circumstances are, but you know that, of course, people are going to have many of these individual circumstances. But in your feeling, these just weren't predicted at all, or there wasn't that sense of wanting to know exactly what needed to be done to deal with the individual lives of the people impacted here.
Yeah, that's completely my view. That I think it's there's obviously a planning process that takes place kind of unbeknownst to us before. And it's really when they get to the point of knocking the door, they're stepping through their plan. And the plan is, how do we just get past this acquisition process and begin development? There's not a clear process that we were either shared or felt party to that was managed by case. What's the impact we're making in lives, and how are we going to mitigate that impact? I think the main conversation shifts quite quickly to valuation, and I know you guys have heard a lot about the valuation question. That luckily didn't happen to us too much, but that's really the question they think that you want to ask.
Yeah.
And ultimately that's where you get to, right? But there's a whole period in that 6 months period, those first few weeks, you don't even want to talk about valuation. You don't want them to call you up and say, hey, can we come around next Tuesday? We need to value your home because we need to get going with this paperwork. Like that, if that's the first interaction, or that's the first stage of the interaction you get, that they go from, we're taking you home, oh, we need to come and value it, when can we come? There's a whole piece in the middle there that's completely missing. And I think that when it happens in a community like ours, where there was no assumption, no understanding that something like this might happen, we don't back onto a freeway, we don't have a hospital right on the boundary line where they might need to expand. This kind of definition of major infrastructure, I think, was really poorly applied here, and the way in which they stepped into it really let people down. And I think that's what caused a lot of the community anger, and that's why we kind of fought back so hard.
I just wanted to thank you for your written submission and the evidence you've given today. I think it really does provide a very important picture that we need to add to what we're dealing with in this inquiry. So, look, you put your case very, very strongly. You have been lucky in some ways, having headed this off, but you've also clearly gone through a very difficult time. So I did really want to thank you for the effort you've put into your submission. That motive for why this happened is doubly upsetting for you, though, that really you feel like you were used to put pressure on the council. That's really what you think was going on when this pressure was applied. Is that correct?
If I may speak to that, I think there's two aspects. Yes, I do think we were used to put pressure on council, but I think the fallback that they would have gone ahead with anyway, if that hadn't happened, is the project that was proposed, the car park on our houses. So I think they saw it as you know, a nice Machiavellian approach here. We'll use these people to blame council if they don't come to the party. That this is why we have to do this other project.
And dealing with the specifics of the proposal, this was clearly an election announcement. It was announced in February 2019. The former Premier came down and made this commitment. In your submission, you say it was subject to winning the election. So it was a conditional commitment. Tell us about the business case, though, what you feel was taken account of, what was in the costing, what was not in the costing, and how that affected this individual case.
We have no insight to that business case. We never saw it. We would have loved to have seen it. We didn't.
Yeah, I think what we could see, the budget that was being provided for the car park was definitely not costed on the basis that there would be compulsory acquiring 9 homes and building on a block, rezoning. And I think when we started trying to piece together, looking at what the budget they had kind of saved up for this versus what we would expect, even as lay people, it would cost, it was far out of whack. That delivering.
But how could that be the case? So it was $17 million announced.
Yeah.
You say, look, it would have cost at least $10 million to acquire our homes. How could you not take that into account if you're planning this project, this commuter car park?
Well, and I think that's where we come back to what's the value for the community here. If this ends up costing $60 million, what value does that give back to the community? And I think that's what we found as residents who would have been kind of stuck remaining around this car park. We couldn't even use the car park. The car park was designed, I think the council, Mike Forshaw, who was the deputy mayor at the time, in the council, really eloquently put it that it's even more galling that you're displacing 9 families to build parking spaces for people who don't even live in the community to drive and have a marginally quicker walk to the station. Feels really out of whack with how we should be kind of spending public money. So the money never stacked up. I think on your point around the Transport for New South Wales and the council, I think the overriding kind of feeling that we had is that we were really being used as collateral. I don't think that there was this big scheme where they said, if we if we threaten these homes, the council will give in. I hope that's not how they would work, but I think it's pretty clear to us that there was a view to go, this would be an option that gets us done in a time frame that we want to get it done. And bear in mind, think back to 2021, we'd gone through one round of lockdowns and COVID. I, for one, haven't been back into the office full time since then. So commuter numbers were down. We're giving 200 spaces, which is probably about not even a third of one train capacity. So we're not really solving a problem here. So we were really questioning, why is time the biggest decision that you're making here? And the only outcome we could come to there is that it needed to be complete before the next state election. So we were really the quick option. When we kind of stood up and said, we're not happy about this and we're going to get together and kind of try and force a conversation with you, we became quite hard basket. And that's when it went back to say to the council, you have 7 days to give us land or we'll take the homes. The question we're asking the whole way through is, if you are that happy to do it quickly, why not compulsory acquire the car park? Why not take the Janelli car park off the council and compulsory acquire that and move at the speed that you want and deliver a better outcome? I think because that would have caused probably a bit more of a headache. They thought they could roll us a bit quicker. And I think that was really disappointing.
Also a bad misjudgment.
Yeah, well, I'd like to think so. I mean, it's it probably didn't do too well for 3 weeks.
I might just finally ask you, you're clearly uncomfortable with the role that Ms. Petnos played, just what you described as the conflict between the fact she was the local member, but also at the time the parliamentary secretary with responsibility in this area. So I might just give you the chance to spell out your views. You refer to it in your submission, but anything you want to put on the record in relation to that.
I can jump in on that. Guys, do you want to say anything?
Yep. No, please do.
Yeah. Look, I think if you look at the base expectation, and I kind of said this in the media at the time, that when something like this hits a community, and like I said, it's isolating, the process forces separation. It's kind of, this will be good for you, but bad for them, but focus on what's good for you. You need someone to kind of show leadership in that. And I think if you don't have your local member representing constituents, and when something like this happens, if you've made the decision and you support it, it's still your job to turn up and put your arm around people and say, I'm sorry this is happening, but this is going to be the benefit, and this is what I'm going to do to support you. I think what I found totally unacceptable in the process was the feeling that they could wait us out, that in us writing letters or making phone calls, and we were making phone calls every day. Personally, I made a phone call every day to her office to say, could we have a meeting? Could we have a conversation? The only time I was responded to effectively on that, bearing in mind I was really heavily involved with Liam, Helmer and others in our community in kind of forcing a dialogue on this, the only time they wanted to speak is when they had devised the ultimatum. So they wanted to talk to us when they had the ultimatum to try and shift the conversation. Outside of that, we weren't afforded a conversation. And I think that just built a kind of building sense of resentment that it's a tough job. And I appreciate that. I know everyone in this committee has a tough job, and there are times where you're not going to be popular, but it's just as important to stand up and put your hand up and own the decisions you're making when that happens. And there's no way there wasn't a conflict of interest in this, right? If you're that close to the transport department and it's within your constituency and you're building transport infrastructure, you knew this was coming. So again, why not put a plan in place? You can make the decisions you want. You're elected to do that, but you have to own them and you have to engage with the community. Like, if there's no consultation coming from transport, the first place we're going to go is our local member. If they're not talking to us either, it's just going to build this resentment. And that's what happened here, that the lid was going to blow on this thing. And it's lucky it ended within 3 weeks, because the stress and the torment within our community was palpable. It was a really, really tough time.
Can I just also add, Alini turned up on our doorstep unannounced on a Wednesday afternoon around 2 o'clock. Liam was home by himself. She had a scribe next to her. Liam wasn't allowed to take notes. I mean, this is just clear bullying and intimidation. This was when she was going to ask for council to hand over the car park. She had organised a TV crew to film her.
And when you say not allowed, Liam was not allowed to take notes. How did you know that?
It just gives you a flavour of the tenor of the conversation. Knock on the door. I answered. 2 people there. One was our representative. The other was an assistant, and there'd been no forewarning. And I said, "What's this about?" And she said, "Oh, I want to talk to you about it." I said, "Well, why wouldn't you speak to us as a group? We've been trying to get a meeting with you. Why can't we have, why?" Again, this surprise tactic, this shock, surprise, get them off balance. So I was floundering, quite honestly. I had lots of arguments, but I was trying to be, marshal my thoughts. And one of the things I asked her was, who's this young lady with you? And she said, she's here to take notes. And I said, well, I haven't got anyone here to take notes. That's what my wife was referring to. But the conversation went on from that, and we were very unhappy that we weren't given a proper, reasonable chance to have a proper dialogue. That was all this media posing. This, I've come to talk to the people, look, and this is on camera, I'm doing the right thing. What do you mean we're not talking to them?
Has it got to the stage where you're hesitant to open the door, given this series of shocks?
Well, yeah, it did for a while. That's for sure.
No, it's made me a lot stronger. The total injustice. Look, I've always been a believer. My parents always said, people do the best. And this, I'm just, very disillusioned. With what people who we elect, who are supposed, we pay for with our taxpayers' money, and they are just total narcissistic bullies.
Thank you very much for your submission to the inquiry, and thank you, Chair.
Thank you, Mr. Graham. Mr. Banasiak, did you want to ask a question, or any of the government members before I?
Yeah, I might just follow up from Mr. Graham there, just with respect to the prohibition on taking notes. Just to clarify that point, Mr. Mulhall, was it that you were stopped from taking notes, or you just didn't have that opportunity necessarily? There was no order on you not to take any notes of that meeting with your local member?
No, it didn't come to that sort of a clear-cut yes or no. It was just sort of poo-pooed, the notion that I'd want to take notes.
I can give some clarity on that as well. We've been requesting meetings numerous times, and like I said, calling every day, and none was afforded to us. So it was really, I think it was irresponsible to just knock on people's doors and wander around the neighbourhood trying to do it. Whether the notes were taken or not, I think that the point is we were looking for structure, and we were looking for a conversation that residents can prepare for, right? Highly emotional, supercharged time. They want to kind of make sure that they can emotionally be stable and talk through the points that are really concerning them. When you knock on their door cold, it's not going to do that. We did call the office, a member of Maran's office afterwards, and request the notes that were taken by her and her team, and those weren't provided to us.
But of course, in terms of any meeting, I've got to say, look, we're all elected officials here, so we've all had meetings. We often like to take the notes because we want to actually have that information to go back and act on effectively. And perhaps when we're in the middle of that conversation, we don't have that ability to do it. So having somebody there to take notes is not necessarily for nefarious purposes, but in order to assist you and being able to do your job as well, and to take up those actions that community members might raise with you. And of course, in these situations, it's a very emotionally charged experience, and I can really understand the position you'd be in and how distressing that would be. But just being able to go and follow up on your actions as well can be important for a local member, particularly when I guess you got to the outcome where there wasn't as arduous as it was in terms of those 3 weeks, that thankfully you didn't have the position of having those homes acquired. And sorry, Mr. Mulhall, I saw you putting your hand up there.
Yes, I think this note-taking issue is a bit of a furphy. We only mentioned it in the context of giving you a flavour of the exchange.
Yeah, but I think you made the point well that it's the structure that you need, the structured engagement. I think that's really come across.
It's
That's it from me, Madam Chair.
Thank you. I guess just picking up on that point, it's also. It makes me question whether this whole process of knocking on the door at all, right at the beginning of the process, is appropriate, because I don't know about you, but I don't think there's ever a good time for someone to knock on my door. I'm always either wrangling the children or in the middle of a conference call or doing whatever. This idea that someone arrives when unprepared, whether it is a local representative or whoever, do you think that is ever a good idea? And would it create a better balance between those being acquired and those acquiring? if there was a more structured process of meetings being held outside of your home.
I just
What are your
can't even
comments on that?
imagine that this wouldn't even be in guidelines to knock. I can't even understand why we're going through this. This would not even be in guidelines. Yeah, I mean, you know, a government organisation that size, that they even thought of doing it.
Yeah, I think the
May I ask a question, if that's all right? Would you have perhaps preferred to receive a letter, as was the previous practice, or would you perhaps prefer a telephone call calling you to a meeting to discuss it as an alternative practice? I might just add by way of comment before asking you to respond. Actually, visiting people and talking with them was something that was put in because it was felt that a letter or a telephone call was too impersonal. So I just wonder if you'd basically respond as to the other possible ways of initiating this conversation, so that we could get a better understanding of what you think might be a preferable way to go.
Thank you.
May I respond to that?
Please do.
What I would think would be a better way to do it would be to involve, consult, and communicate with us prior to the decision being made, to tell us that there's a possibility that our homes will be evicted from our homes, to explain why this would be necessary, and to assure us that other alternatives were being looked at. The fact that you're presented with a fait accompli, you are leaving this house, you are going to be evicted. You know, whether you get that in a letter, someone knocking at the door, it's going to be a huge shock. Which is, yeah, sorry.
I think on my view there, I think I wouldn't focus so much on the input, I'd focus on the output. I think whether someone calls you up, knocks on your door, sends you a letter, I'm more worried about, is that person that's then been notified feeling comfortable, they're aware of what's going on, aware and consulted on the decision process, or are they left with the information that makes them kind of start to process and understand what happens next? I think at the moment, whether you call someone up and spend 15 minutes saying, we're going to compulsory require your home, or you knock on the door and tell them, the abrupt nature of that dialogue, and then the feeling that you're then left to kind of sit and dwell on that on your own, is a bad output. It sounds like if they've done telephone calls before, there's people who have paid far more money than any of us, I'm sure, on this kind of process and the semantics and how it's best delivered. I think what we would really want to focus on is really considering, instead of we've hit the date, we've knocked on the door, so the process has started, so let's get to the next plan. Thinking about when we knock on the door, let's focus on the people whose door we're knocking on and make sure that they are looked after in that time and they're fully aware of their decisions. Because there's a common practice, and I'm sure you would have all experienced it, that when this is announced and doors are knocked on, there are a stream of ambulance chasers who turn up on your doorstep or in your street the next week saying, we will offer you support, we've done this before, we're legal advisors, we can help. And that's where communities go to get the help, because there's no other position. And I think that's where we're looking at that intermediary kind of support to go, is there someone that you are afforded to talk to who isn't someone who's trying to expedite the process, who can give you that support? And whether that's the first interaction is telephone call, letter, or knock on the door, I think that's up for Transport to kind of find the best formula and make that decision based on the people who you're contacting.
So it sounds to me then like there's sort of two elements to this. There's the having some sort of understanding that this might happen, so that you feel that it's not just a done decision by the time you get notified, it's sort of out of the blue. So some sort of notification that this may be something, and perhaps even better, some input into the decision as to whether or not it happens. But then on this point of how you get notified, I can imagine people thinking that, you know, people turning up at your door would be good because they could look after you and help you. But if what you're getting is actually people turning up at the door who just tell you and then leave, you may as well have a phone call or a letter. So again, is Mr. Richards that sort of outcome focus?
Yeah, exactly.
How do
Is
we
it the
leave
right
people after it? Yeah.
And in terms of the consultation process for those who aren't having their door knocked, we were desperate to consult and go, what's happening? We were just told that will happen in 6 months once the compulsory acquisition process is complete. And I think that lack of consultation just causes a swirl within communities that means it's separated. Different people have different motives and intentions. And I think it's purposefully designed to create a bit of chaos to get through that process quickly. You can lose 3 months in a compulsory acquisition process in a blink. Like when you're in that emotional state and you start trying to be a backyard lawyer, the time will disappear and it's against you.
So before I'll give the government another chance, I just want to ask one more question before I do. You mentioned before, Mr. Richards, this kind of focus, I guess, on compensation amounts and on, how much you're going to get paid out for your house in a similar way, I guess, to how you might do a business acquisition as opposed to actually buying someone's home. You mentioned before that money is not what you're thinking about in that first period of time. And in your case, presumably you were thinking about how do we stop it? But also, I remember when we spoke in April and the Mulhol's neighbour was talking about having to work out what she would do with children and which schools they would go to and trying to plan the school year. Can you give us some examples of the types of things that people are thinking of in those first few weeks that they really need help with?
Well, for me, Liam and I had planned to be here in our retirement. We've organised our home. We've done renovations because we love it here. I've also got my neighbours. I've got my beautiful community, which I just love. There is no way with what we would have been compensated with, and there weren't at that stage any houses to buy in Janelli. Houses just don't last here at all. I was going to be displaced from my community. Everything that I've known, and I would have had to have started anew. It was, for me, that was the most devastating things. We're a very close-knit community. I go over and look after the kids across the road. People, it's just, it's a beautiful thing. And we couldn't have lived here. I would have had to have moved, and I wouldn't have got what I've got here.
Yeah, I think when you kind of look at the brass tacks of the market rate and valuation, I think you're quite often left with the feeling that it's going to be very, very difficult to buy something comparative in the same area. Like, as Emma said, number one, stock is an issue, but there were 9 families potentially having to find the same house. So there was a very real scenario that 9 families would all be turning up to the same auction to buy the same house, which is even worse of an outcome. And then number 2, the money you're getting at fair market rate isn't necessarily going to get you a like-minded property somewhere else, because that's not the market. And I think back in February 21, the market was crazy. It's even worse now. So I would feel awful for anyone. I know Riverwood, there's some people we've been speaking to are going through that process now. When you were given the value of your home 6 months ago and cashed out 6 months later, you're never going to be able to go and buy that property of equivalent value in the market as it currently is. And I think that's a real concern. People, when they start looking down the barrel of this is going to happen and the compulsory acquisition process is going to happen, straight away you're looking at, how do I stay within the catchment area of the school? How do I stay within the community? How do I replicate the life I have? And I think that's near impossible in a community like Janelli. I don't think there would have been the stock or the opportunity. So if there was a way to help that process, I think it needs to be looked at in terms of, is there an addition to the fair market value given as almost an opportunity to help you get back into the market, even if that is slightly more than your home is currently valued at? So is there a penalty rate for the government to come in and displace you in this way? And then is there a support in which the government or transport can help you acquire that property? Here in Janelli, one of the homes to kick off the process was actually bought outside of auction by the government. So they kind of shut down the auction and put claim on the property, caveated the property and said, we're going to buy that. Is there a way in which the government can help find people equivalent accommodation and move? I don't think that's a preferable route, but I think there's more that could be done to look into that. And again, focus on the outcome of the individuals. Like, the car park is down the road. Think about the first 2 months of this process. How are you going to help people understand? Because bear in mind, they're living their life at the same time, right? We were all going to work every day. We're all taking kids to school. We had our lives continuing around this. We couldn't just spend 3 weeks kind of mulling a compulsory acquisition process. We were still doing what we needed to do and then worrying about this on top of that. So yeah, a few suggestions, but yeah, I think you guys will have a firmer view on that.
And as you said right at the beginning, it's not about being anti-development or anti-change. It's about being made whole in the process, and that's more than money. It's a lot more than money. Did any of the government members or the opposition like to ask a final question? Some shaking heads. Well, we are incredibly running on time again for this session as well. That does conclude our hearing.
Somebody wanted to ask.
Oh, sorry. Did you want to ask one
There was
last?
someone waving. I'm not sure if they're waving. No
Yeah,
question.
that was
Yes,
sorry,
question.
that was me, Abigail. I've been waving for a while now.
Cannot see you. I'm so sorry. Go ahead.
No, that's all right. I was just wanting to ask a clarification question to Mr. Mulhall. When Miss Petnos came to your door, where was the cameraman in relation to your house? And what capacity was she actually talking to you as? Was she talking to you as your local member, or was she trying to talk to you as the Parliamentary Secretary for Transport?
The latter question, I have no idea. The conversation didn't proceed on that basis. There was somewhere on the street, I can't recall precisely where.
Across the road.
Across the road, yeah.
They were sitting in the car waiting for, yeah.
And they did get out of the car at one stage, but at this stage, a lot of fellow residents had come together. And I saw the camera crew on the street.
Yeah.
But they weren't at my front door, if that's what you're asking.
Yeah,
In other words, there was no camera crew.
Yeah.
Despite the impression you sought to give earlier, there was no camera crew on your property.
I was just trying to get clarification as to where they were and what they were doing. That's fine. Thank you.
If it's beneficial to you all, it was a Channel 7 news crew, and I think there's a YouTube clip of it, so we can supply that. Obviously, it's edited by news and media, so it's kind of their take on the events, but that will give you proximity if that's useful to you.
Okay, thank you.
I think that would be very useful, actually, if you could send that through to the Secretariat.
No problem. Yeah.
That would be great. Apologies again, Mr. Manasiak, for missing your waving hand and your message saying you wanted a question. Was there any other final questions before I conclude our hearing? I can't see any waving hands. Okay. So thank you very, very much for attending and for giving such compelling evidence to us today about the very human impact of these acquisitions on people. And it's definitely given us some direction for our recommendations. So thank you very much. That does conclude our hearing for today. To the extent you've taken any questions on notice, I don't believe you did, but the Committee Secretariat will be in touch. And that